I have the pleasure to introduce the first speaker, Delsia Marshall. She's been with the firm of Fitzgerald and Fitzgerald, which is one of the preeminent plaintiffs' firms in New York. They do an extensive amount of lead litigation, and she was recently involved in the lead malpractice case that resulted in a verdict of $3.5 million. It's a pleasure to welcome Delsia to talk to us about the introductory parts of the lead lawsuit.
What are your other potential defendants? Well, of course, we mentioned the landlord, which usually you'll have a corporate entity as your landlord. You'll have some cases in which you'll have individuals, but you're looking now to see whether the LLC, what you can do about that as a plaintiff. You'll have the LLC as a potential defendant, but how can you get them named in your case? What are you looking for? We have a case cited here that we can't get to the LLC in terms of the individual members as a defendant unless we can show more than that the person was just a member. In other words, if they're just a member but you don't have any course of tortious conduct, you're going to have a difficult time keeping that particular defendant in your case. You're thinking about whether you'll be able to utilize the doctrine of passing the corporate veil, but of course the plaintiff does have a heavy burden to carry. Managing agents, these things are thought about case by case in terms of managing agents, independent contractors. What is their level of negligence? Is there, in terms of the managing agent, was that managing agent in complete and exclusive control? Of course, pre-suit, you may have a lease with the managing agent's name on it. The prospective client may know a few names, but they won't be able to answer this question completely as a plaintiff. Maybe in discovery, when you get to that defendant's deposition, you'll really get an answer. So pre-suit, you're really looking to project, do I expect that I'll have enough information? What types of conduct has been demonstrated by this particular potential defendant? So it's really a case-by-case analysis if they're going to meet your standard as a potential defendant in the case. Sometimes the independent contractor that you might consider is the lead abatement contractor. We tread a little lightly with that, partly because the lead abatement contractor often has some contractual relationship with the owner. Pre-suit, you don't have all the information. However, down the line, what we look at, perhaps if the lead abatement contractor's conduct has caused the child's lead level to increase, or you have reason to believe that, what sometimes happens is the defendant pleads their own lead abatement contractor, and then we will turn around and determine whether we want to also assert a claim against the lead contractor at that point. But pre-suit, you may not have all of your information intact. Daycare centers, yet another potential defendant. And of course, they have a duty to abate. They have a duty to abate the lead paint hazard. And that Espinal case cited is a good case to look at. Espinal versus 570 West 150th Associates, listed on page 9 of your materials. Last but certainly not least in terms of potential defendants when you're thinking of the lead case as a negligence case is a municipality. The Court of Appeals Pelea's decision has made it difficult to establish a case where the municipality is not the owner of the premises that you're seeking relief against. However, there are some exceptions based upon the existence of a special relationship, and I've had the opportunity to work on a couple cases even after Pelea's where we established the existence of a special relationship and the case did move forward. However, if you look at the criteria such as assumption of a duty, the municipality assumes positive direction and control, the municipality violated a statutory duty for the benefit of a particular class of persons. Those are difficult criteria to establish generally. So from a plaintiff's perspective, unless the municipality right now is the owner, you're going to have an uphill battle establishing a viable case against the municipality. There are a paucity of cases where you'll find the City of New York as the owner or the New York City Housing Authority as the owner. Housing Authority, basically, there are some cases, but you're looking at their own scheme where they often have abated the premises before the client comes to you. So you're having a situation where the child may have an elevated level. You believe the elevated level was caused by exposure in the Housing Authority apartment, but by their own internal system, the apartment's abated before the potential plaintiff has noticed that they have a case. So you have basically an uphill battle. I'm not saying that we don't have cases against Housing Authority in the City of New York, but there are fewer since these decisions. Before these decisions came down, you were looking to whether there was a private right of action. You were looking whether you could sue Section 8, for example. That's basically been foreclosed. That analysis of discretionary function will pretty much foreclose you from asserting a claim against, for example, the Housing Authority based upon what you believe to be a negligent Section 8 inspection. So that's not going to be a viable claim. But there are some cases in which, as I said, the Housing Authority or the City of New York, you'll have them as a landlord, and if you can establish that there's lead in the apartment, the child was exposed in the apartment, you still will go forward, and we have.